So it's very, very important if you want to get your comments on the record that you sign up to speak at this meeting. You must, because if it goes higher, once it goes higher, if you're not on record, you cannot speak at that level on any of the rezoning cases, the ones that begin with Z. Z something. Yes, sir. Please fill it out. How you doing that, sir? Eric's not gonna be here.
Good morning, everyone. It is 8:30 and we typically start right on time, but we're still trying to work out a little bit with the court reporter who apparently got sick last night and had to call out today. So just be patient with us for just a couple of minutes. We're trying to resolve it as quickly as possible.
Oh, allow access, I don't know. Oh, I'm there. Okay. Thank you for your help.
Okay, thank you.
All right, bye.
Michelle?
Yes.
Hi, good morning. We're going to go ahead and get our meeting started. If you'd like to go ahead and mute yourself, that way the whole room can't hear you, but I want to make sure you can hear me okay.
Yes, I can hear you okay. They're board members. I have no names. I have no access to anything, so I won't, I don't.
They're going to say their name and we'll.
Would you prefer me to email you their names? Or would you like?
Well, that would be great to have proper spelling, but I guess anytime anybody speaks, if they can just say their name in the beginning so they're identified on the record. Otherwise, I won't know who's speaking since the camera's not showing them. Is that okay? They say that their name every time?
Yes, everybody understand? Okay, we'll go ahead and do that. I will also say that there are several, with our cases, we will be reading off findings and things of that nature, and I can email you those after the meeting to make that a little easier too.
Okay, great. So anybody who speaks, just state their name and we should be good to go. I'm sorry if I have to interrupt if I don't hear anything.
Perfect. And just to reiterate, if everyone can use their microphones, please make sure they're on. That is the only way the court reporter will be able to hear you.
And Rachel, please state for the public what's going on. There may be some about it.
And just to reiterate to the public, we have a court reporter, but they are connected through Microsoft Teams. They are not here in person. So when you do come to the microphone, please state your name. Michelle, are you able to swear in?
That would only be with a driver's license to the camera.
Okay. I'll go ahead and swear in. Each person who comes up to speak, I'll go ahead and swear them in.
Okay, that's fine.
All right.
All right, good morning, everyone. This is Wayne Brisky, Chairman, speaking. I'd like to hereby call to order the rezoning meeting for June 7th. We do have all but one of our members, so we do have a quorum. And at this time, I'd like to ask everyone to stand for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you again, Wayne Brisky speaking. Please turn off any kind of noise makers so we don't interrupt the meeting. And I'll ask staff at this time, do we have proof of publication of our hearing?
Yes, sir.
Okay, and does that publication meet all of the legal requirements?
Yes, sir.
Chair will entertain a motion to waive the reading of the legal.
Gary Sammons moves.
Okay, do we have a second?
Tim Pyle seconds.
Thank you. All in favor, say aye.
Aye.
And that is unanimous. The rezoning meeting minutes from the previous meeting were provided to the board members. Are there any additions, deletions, or corrections? Hearing none, the chair will entertain a motion to accept.
Gary Sammons moves.
Tim Pyle seconds.
All those in favor, say aye. Aye. Opposed? Motion carries unanimously. The rezoning hearing package for June 7th, 2022, and the findings of facts has been provided to the board members. The chair will now entertain a motion to accept that rezoning hearing package with the findings of facts and the legal advertisement into evidence.
Gary Sammons moves.
Jay will second.
Thank you. All those in favor, say aye. Opposed? Motion carries unanimously. The rezoning hearing package with the findings of facts and the legal advertisement will be marked and included in the record for all of today's cases. At this time, we'll ask our staff member to swear in those members of the staff that will be testifying.
Please raise your right hand. Do you solemnly swear and affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Allison, say your name.
Allison Lindsay. Allison Lindsay, I do.
Horace Jones, I do.
All right, thank you. Do we have anyone else that's testifying from staff? Okay. Do we need to, Rachel, are you going to be testifying?
I will not be testifying.
Yes, okay. Okay, so we have everyone sworn in. Okay, very good, thank you. Okay, board members, you've previously qualified these two individuals as experts in the area of land use and planning. Do any of you have any questions regarding their qualifications or their ability to offer that expert testimony? All right, hearing none, the chair will accept these two individuals as experts in the area of land use and planning. At this hearing, the Planning Board is acting under its authority to hear and make recommendations to the Board of County Commissioners on rezoning applications. These hearings are quasi-judicial in nature. Quasi-judicial hearings are like evidentiary hearings in a court of law, however, it is less formal. All testimony will be given under oath, and anyone testifying before the Planning Board may be subject to cross-examination. All documents and exhibits that the Planning Board considers will be entered into evidence and made part of the record. Opinion testimony will be limited to experts, and closing arguments will be limited to the evidence in the record. Before making a decision, the Planning Board will consider the relevant testimony, the exhibits entered into evidence, and the applicable laws. Each individual who wishes to address the Planning Board must complete a speaker request form located at the back of the chambers. You will not be allowed to speak unless we receive a completed form. Please also note that only those individuals who are present and give testimony on the record at this hearing will be allowed to speak at the subsequent hearing before the Board of County Commissioners. No new evidence can be presented to the BCC. Therefore, all testimony and evidence must be presented today. The Planning Board will provide a recommendation for each rezoning request to the BCC. They will then review the testimony, documents, exhibits, consider closing arguments, and make a final decision. All decisions by the BCC are final. Anyone who wishes to seek judicial review of that decision of the Board of County Commissioners must do so in a court of competent jurisdiction within 30 days of the date the BCC either approves or rejects the recommended order of the Planning Board. All written or oral communications outside of this hearing with members of the Planning Board regarding matters under consideration today are considered ex parte communications. Ex parte communications are presumed prejudicial under Florida law and must be disclosed as provided in BCC Resolution 96-13. As each case is heard, the chair will ask that any board member who has been involved in any communication identify themselves and describe the communication. The rezoning criteria. As required by Section 2-7.2 of the Escambia County Land Development Code, the Planning Board's recommendation to the BCC shall include consideration of the following approval conditions. Approval conditions. The applicant has the burden of presenting competent substantial evidence to the reviewing board establishing that the requested zoning district would contribute to or result in logical and orderly development pattern. The appropriate surrounding area within which uses and conditions must be considered may vary with those uses and conditions and is not necessarily the same area as the mailed notifications. A logical and orderly pattern shall require demonstration of each of the following conditions. A, consistent with the comprehensive plan. The proposed zoning is consistent with the future land use category as described in LDC Chapter 3 and with all other applicable goals, objectives, and policies of the comprehensive plan. If the rezoning is required to properly enact a proposed FLU amendment, it must be transmitted to the state agency for review. The proposed zoning is consistent with the proposed FLU and conditional to its adoption. B, consistent with zoning district provisions. The proposed zoning is consistent with the purpose and intent and with any other zoning established provisions prescribed by the proposed district in the chapter. C, compatibility with surroundings. All of the permitted uses of the proposed zoning, and not just those anticipated by the rezoning applicant, are compatible as defined in Chapter 6 with the surrounding uses. The uses of any surrounding undeveloped land shall be considered the permitted uses of the applicable district. Compatibility is not considered with potential conditional uses or with any non-conforming or unapproved uses. Also, in establishing compatibility of a residential use, there is no additional burden to demonstrate compatibility of specific residents or activities that are already protected by fair housing laws. And D, appropriate if spot zoning, where the proposed zoning would establish or reinforce a condition of spot zoning as defined in Chapter 6. The isolated district would nevertheless be transitional in character between the adjoining districts, or the differences within those districts would be minor and sufficiently noted. The extent of these mitigating characteristics or conditions demonstrates an appropriate site-specific balance of interests between the isolated district and the adjoining lands. E, appropriate with changed or changing conditions. If the land uses or development conditions within the area surrounding the property of the rezoning have changed, the changes are to such a degree and character that it is in the public's interest to allow new uses, densities, intensities throughout the rezoning, and the permitted uses of the proposed district are appropriate and not premature for the area or likely to cause or contribute to sprawl. At the beginning of each case, as long as there are no objections from the applicant, we will allow the staff to briefly present location and zoning maps as well as photographs for the property. Then we will hear from the applicant and any witnesses that they may wish to call. Then we will hear from the staff and any witnesses they may wish to call. Finally, we will hear from members of the public who have completed a speaker request form. We do have two cases today, and we will go ahead and jump directly into them. The first case is case number Z 2022-05, being presented by Tom Hammond, who is the agent for 95A Ventures LLC, who is the owner. 4100 block of North Highway 95A, 230.41 plus minus acres, from agricultural district, 1 dwelling unit per 20 acres, to RR, rural residential district, 1 dwelling unit per acre. Members of the board, I'll ask now if there's been any ex parte communication between you. I'm sorry.
Let me make a correction. You said RR is the 1 dwelling unit per 4 acres.
4, I'm sorry.
Yes, sir. Yes, sir.
All right.
I want to get it.
And what was your name?
Thank you. My name is Horace Jones. Thank you, Mr. Reed Rushing.
Thank you. I think I get glazed over reading all of that legalese in there, so. All right, members of the board, I'll now ask if there's been any ex parte communication between you, the applicant's agents, attorneys, witnesses, fellow planning board members, or anyone from the general public prior to this hearing. I'll also ask if you disclose if you have visited the subject property and disclose if you are a relative or business associate to any of the parties. And good morning, Steve.
Good morning. Steve Opalinick, no to all.
Gary Sammons, no to all.
Tim Pyle, no to all, familiar with the location.
Wayne Brisky, no to all.
Jay Ingwell, no to all.
Walker Wilson, no to all.
Reed Rushing, no to all.
All right, thank you. Staff, was there a notice of the hearing sent to all interested parties?
Yes, sir.
Okay. And was the notice of hearing posted properly on the subject property?
Yes, sir.
Okay. Mr. Hammond, any opposition to the maps and photography? No, sir. Okay, he's indicated there is none, so we'll have staff present the maps and photography.
Good morning, Chairman and Board. Allison Lindsay, Urban Planner, Development Services. This is the Z 2022-05. Here is the location map showing the location of this property. This is the 500-foot radius map showing the property currently as agricultural. Here's a future land use of RC, rural community. This is the existing land use map. This is the aerial and the wetlands map. This is the public hearing sign posted on site. This is looking into the subject property. This is looking south along Highway 95A from the subject property. Looking north on Highway 95A. Looking west across 95A from the subject property. And that's all the maps.
Okay. Board members, any questions about the maps or photography before we bring up the applicant? All right, Mr. Hammond, good morning, sir. Sir, if you'll please be sworn in, state your name and address for the record, please.
Please,
Tom Hammond, 3802 North S Street.
please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
Thank you.
All right, thank you, Mr. Hammond. Have you received a copy of the rezoning hearing package and the findings of fact?
Yes, sir.
Okay, do you understand that you have the burden of providing substantial competent evidence that this proposed rezoning is consistent with the comp plan, furthers the goals, objectives, and policies of that plan, and is not in conflict with any portion of the Land Development Code?
Yes, sir.
All right, thank you, sir. Please proceed.
Good morning. I'll just go straight to the criteria.
Yes, sir.
Consistency with the comprehensive plan. Goal, Flu 3 rural strategies from the comp plan that's in my package. Escambia County will promote rural strategies including protecting agriculture, silviculture, and related activities.
Excuse me, Mr. Hammond, can you pull the microphone a little closer? Yeah, sorry, it's not picking up very well.
All right, sorry.
Thank you, sir.
Natural resources and guiding new development toward existing rural communities, and we're in the rural communities. Future land use. Also, Flu 3.1.4, rezoning. Escambia County will protect agriculture and rural lifestyle of northern Escambia County by permitting rezonings to districts, allowing for higher residential densities in the rural community future land use category. Also, in rural communities, you can go down to 2 units per acre, and we're only asking to go to 4. With our, what we're requesting in a rezoning. So we meet the comp plan. Criteria B, consistency with the zoning district provisions. Section 3-2.3 rural residential district. Rezoning the rural residential zoning may be established only within the agricultural and rural community future land use categories. This district is suitable for rural areas not used to support large farming operations due to economic viability, soil productivity, surrounding development, or similar constraints. This district is appropriate to provide transitions between areas zoned or used for agriculture, conservation, or outdoor recreation and areas zoned for use for rural mixed use or low density residential. So we do meet consistency with the zoning district provisions. Compatibility with surroundings. The parcel was bordered by ag zone parcels to the east and west and rural residential zone parcels to the north and south. The surrounding parcels are all either undeveloped or single-family residential lots with an approximate minimum lot size of 2 acres. We intend to develop the parcel into a single-family residential subdivision with a minimum lot size of 4 acres. The proposed rezoning is compatible with surrounding uses. Appropriate if spot zoning. It's not spot zoning, we have rural residential to the north and the south. E, appropriate with change or changed conditions. We're not aware of any changed conditions. So that asks you if you accept my findings of fact, and if you did that, you'd also be accepting their findings of fact.
Thank you, sir. Any questions for Mr. Hammond? All right, if you'll just give me a moment. We don't have anyone who has signed up to speak on this case yet. Is there anyone here that is going to want to speak on this case? All right, in cases when the applicant and the staff's findings are in agreement, we can do it expedited so we don't have to go through every one of them. Allison, could you say if the county is in agreement with the findings, and if so, then we'd be ready to move forward?
Yes, sir. Allison Lindsay. Yes, this case does meet all the requirements of the comp plan and the land development code. And it is consistent with their request to rezone. So we are, it is consistent.
Okay, board members, as you know, in the past, we've expedited approvals when everything is, meets all the standards and the applicant has brought forward substantial competent evidence. Is there anyone willing to make a motion at this point, or shall we go through all of the findings?
Walker Wilson, I'll make a motion to expedite the hearing.
Thank you, sir.
Reed Rushing, second.
All right, any discussion? All those in favor say aye. Aye. Opposed? Motion carries unanimously. Thank you, Mr. Hammond. Thank you. All right, we will now move directly on to our next case. And Ms. Bush, do you have any opposition to the pictures and photography being done? Okay. Members of the board, has there been any ex parte communication between you, the applicant, agents, attorneys, witnesses, fellow planning board members, anyone from the general public prior to this hearing? Also, have you visited the subject property, disclosed if you're a relative, business associate, applicant, or applicant's agent, or if you are related to any of the parties? And I need to introduce the case as case Z 2022-06. Meredith Bush is the agent for Rockford Corporation, who is the owner, 210 Broadmoor Lane, 1.65 plus minus acres, MDR, medium density residential, 10 dwelling units per acre, to HDR, high density residential district, 18 dwelling units per acre. And Steve, any ex parte communications on the case?
Steve Opalinick, no to all.
Gary Sammons, no to all.
Tim Pyle, no to all.
Wayne Brisky, no to all.
Jay Ingwell, no to all.
Walker Wilson, no to all.
Reed Rushing, no to all.
All right, thank you. Staff, was notice of the hearing sent to all interested parties?
Yes, sir.
Okay, thank you. And was it also properly posted on the subject property?
Yes, sir.
Okay. And Ms. Bush has indicated she's okay with us presenting the maps and photography, so if we'll bring those up, please.
Allison Lindsay, urban planner. I would like to mention before we get started that this case was actually advertised as HDMU, and the applicant had changed their request to HDR. So you may see some things on here that say HDMU, but they've asked for a lower zoning of HDR.
Okay, Chairman Wayne Brisky. Allison, on that note, has the findings of facts been correctly presented, or are we proposing after the meeting?
Yes, sir. We've revised our staff findings for HDR, and the applicant also gave us a new packet that represents her HDR request versus HDMU.
Okay, so everything in the package is correct. It was just the way it was advertised?
Yes.
Okay, all right, very good. Thank you.
Okay, so here's the location map showing the location. This is the radius, 500-foot radius zoning map showing the current MDR. This is the future land use of mixed-use urban. And this is in the CRA of Barrancas overlay. And this is the existing land use map. And this is the aerial photo of the site. Here's our public notice hearing on site. This is looking into the subject property. This is looking across the street from the subject property on Broadmoor. This is looking northwest from the subject property. This is looking at the adjacent parcel to the west. Looking southeast toward Barrancas from the subject property. And that's the maps and photography.
Allison, would you go back to just the overview of where the property's located within?
So if you go over the Barrancas Bridge, it's like the second road right there on, take a right.
Okay, and this is outside the city boundaries as I'm seeing now.
Yeah.
I knew the line was over there somewhere, so, okay, thank you. Ms. Bush, if you'd like to come forward, please. Good morning.
Good morning, Meredith Bush, here on behalf of the applicant, 125 East Intendencia. I'm an attorney with Clark Partington.
All right, thank you, Ms. Bush. Do you understand that you have the burden of providing substantial competent evidence that the proposed zoning is consistent with the comprehensive plan, furthers the goals, objectives, and policies of that plan, and is not in conflict with any portion of the Land Development Code?
Yes, sir.
Did you also receive a copy of the rezoning hearing package with the findings of facts?
Yes.
Okay, please proceed.
Thank you. I do appreciate staff's time working with us. We did initially submit for HDMU, but after conversations with the CRA director, realized HDR would be a better category and one that the county could support. So I'll dive into the criteria. As to criteria A, consistency with the comprehensive plan, the proposed amendment is consistent with the intent and purpose of the current future land use category of MUU. It also is supported by FLU 1.5.1, new development and redevelopment in built areas to promote the efficient use of existing public roads, utilities, and service infrastructure. The county will encourage the redevelopment in underutilized properties, which this is one within the overlay, to maximize development densities and intensities located in the MUS, MUU, commercial, and industrial FLU categories. As to criteria B, the proposed amendment to HDR is consistent with the purpose of the Land Development Code. The parcel is adjacent to medium-density residential and commercial zoning districts. The high-density residential district establishes appropriate areas and land use regulations for residential uses at high densities within urban areas. The primary intent of the district is to provide for residential neighborhood development in an efficient urban pattern of well-connected streets and at a greater dwelling unit density and diversity than the medium-density residential district. Residential uses within the HDR district include most forms of single-family, two-family, and multifamily dwellings. And so the amendment will be consistent with the zoning district. Compatible with all surroundings. The proposed amendment is compatible with the surrounding existing uses in the area. Within a 1,000-foot radius area, the applicant identified properties within zoning districts of COM, MDR, and HDMU. Within a 1,050 radius, there's HCLI zoning present. The existing surrounding development is mixed to include residential and commercial. To ensure additional compatibility with existing adjacent uses, if the amendment is approved, further review and evaluation through the DRC process may be necessary. As to criteria D, spot zoning, the amendment request, if granted, would be appropriate as transitional in nature. The Land Development Code does not prohibit spot zoning. In this case, where the proposed zoning would establish or reinforce a condition of spot zoning as defined in Chapter 6, the isolated district is still appropriate because it would nevertheless be transitional in character between the adjoining districts. The property is situated between the adjacent commercial zoning and adjacent MDR zoning. Section 3-2.8F of the code actually specifies that HDR is an appropriate transitional category between MDR and commercial. And then finally, as to criteria E, appropriate with changed or changing conditions. We're not aware of any changed conditions based on the existing uses and intensities and the zoning district allowances. The proposed amendment would not create urban sprawl and would be compatible with existing development. It is in the public interest to allow HDR zoning to create a transitional zone between the MDR and COM properties. The change is appropriate in an area that is surrounded by a mix of commercial and residential uses, and the proposed rezoning will contribute to a logical and orderly development pattern. And I'm happy to take any questions.
Okay. Wayne Brisky, thank you, Ms. Bush. Do you have any other witnesses that you want to present in the case?
No, not at
Okay.
this time.
Questions from Ms. Bush at this point? Okay. We'll let the staff do their portion, and then we do have speakers on this, so we'll go through the full package. Allison?
Okay, Allison Lindsay. So this is a case requesting to change from medium-density residential to high-density residential. So consistency with the comprehensive plan. The proposed amendment to HDR is consistent with the intent and purpose of the future land use mixed-use urban. Mixed-use urban FLU is compatible infill development and the separation of urban and suburban land uses within the category as a whole. The uses available include residential, retail, sales and service, professional office, light industrial, recreation facilities, public, civic, and limited agricultural. The amendment is also consistent with the intent of the future land use 1.5.1 and FLU 2.1.2 by making use of the existing public roads and the availability of the existing utilities and service infrastructures. Consistent with the zoning district provisions, this is in the Barrancas overlay area, and the permitted uses, they vary in the location of the Barrancas overlay. Multifamily, one of the requirements for the Barrancas overlay is multifamily developments shall be in a form of condominiumship ownership. So the proposed high-density residential zoning is suitable for single-family, two-family, and multifamily dwellings. And the CRA department is here also to answer any questions regarding the Brancos overlay. Compatible with surrounding uses. The proposed amendment is compatible with the surrounding residential existing uses in the area. The applicant has stated that the proposed rezoning is for residential use, and within the 500-foot radius area, the properties are zoned MDR and commercial. The surrounding parcels along Broadmoor are single-family and multifamily. Criteria D, appropriate if spot zoning. The request would be considered spot zoning by definition, but because there is no other HDR zone properties near the subject parcel. However, the HDR is intended for single-family and multifamily uses, and the surrounding properties between Broadmoor and Seamarge are residential in zoning and use. Criteria E, appropriate with changed conditions. The land uses or development conditions within the area surrounding the site have not changed, and the request to rezone would allow more residential units and appropriate for the area. And that's the staff findings.
Wayne Brisky, thank you. Allison, did you wish to bring up the representative from the CRA to testify at this time?
Yes, this is Ms. Clara Long.
Okay. Good morning. We've met Miss Long before. Good morning. If you'll, I don't think you were here when we swore in staff members, were you? Okay. So if we'll please swear you in then.
Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God? Thank you.
And if you'll just state your name and position, please.
Well, Clara Long, I'm the Director of Neighborhood and Human Services, and the Community Redevelopment Agency is one of my divisions that I represent. I have talked to the attorney.
Closer to the, there you go.
Good
Sorry.
morning. I have talked with the attorney about the usage, and we are all in favor of it. I did mention that a lot of times we do like to have like neighborhood meetings to let the the community know what's being developed and just get some feedback to get the buy-in from the community. We haven't had that, but I'm looking forward to it as we move forward in this progress, that we do have that that community input on the development.
Wayne Brisky, so CRA is in support of the change then?
Yes,
Okay.
from the higher use to the more residential usage, yes.
Okay, very good. Board members, any questions of Ms. Long?
Tim Pyle, just my question, either for yourself or Ms. Lindsay. The property that's currently at the northwest adjacent to it those are apartments, is that correct?
Yes.
And that falls under, what was the, is it MDR?
Currently it's
Yes.
MDR, yes.
It is MDR, but there are apartments there now.
Yes, and they may have been there prior to the zoning, because as you know, the MDR doesn't allow for the multifamily.
Correct. Okay, I just wanted, it didn't jive with my mind about spot zoning when, anyway. Thank you very much.
Board members, anything else for Ms. Long? All right, thank you very much. That wasn't too bad. All right, Allison, did you have anything else you wanted to add?
No, sir.
Okay. Ms. Bush, any cross-examination or anything to add before we go into public comments? Okay. Okay. For those members of the public who wish to speak on this matter, please note that the planning board bases its decisions on the approval conditions and exceptions described in 2-7.2 of the Escambia County Land Development Code. They're currently up on the board. During our deliberations, the planning board does not consider general statements of support or opposition. Accordingly, please limit your testimony to one of these approval conditions and exceptions described in 2-7.2. Please also note that only those individuals who are present today and give testimony on the record at the planning board will be allowed to speak at the subsequent hearing before the Board of County Commissioners. We do have Mr. Stephen Caruso. Good morning, sir. We'll have you sworn in and then state your name and address, please.
Please raise your right hand. Do you solemnly swear and affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Thank you, sir. Good morning. Please state your name and address for the record.
Stephen Caruso, 206 Broadmoor Lane.
Okay. Thank you, sir. Your comments.
So
What I would like to say about this today is the Broadmoor Road is very narrow, and the only frontage for road for this piece of property is on Broadmoor Lane itself. So the traffic would increase considerably from what we have now. Of course, I'm a little bit opposed to it. I know when I got the record, it was to change to MDR to HDMU, and now I'm finding out it's HDR. But nonetheless, it's mostly residential area, small community. I know the property has been for sale for quite some time, so I'm just wondering what the auspices is for requesting the rezoning is maybe to move this property along and get it sold. So my point of view is I'm against it. I feel the traffic would be increased and be a problem. I appreciate your time today and look forward for you guys to look into due diligence on this request. Thank you.
Wayne Brisky, thank you, Mr. Caruso. Meredith, do you have any questions for the witness? Okay. Allison, any questions? Board members, any questions? Okay. Is there anyone else that wishes to speak on case Z 2022-06? All right, hearing none, we will hereby close the public comment portion of the meeting. Ms. Bush, if you'll come back forward, I'll give you opportunity to give some closing statements.
Sure. I do appreciate your time, and to address Mr. Caruso's point, traffic will be addressed during any development review process, any traffic impacts. The property has been on the market for a while, and this is part of a transaction. The area is in need of redevelopment, and this would help that redevelopment to occur. So we would just ask that you accept staff's findings, accept the updated report from the applicant to HDR, and approve the rezoning request.
Wayne Brisky, Ms. Bush, the findings of facts did say that in fact it was spot zoning. Now I know in your presentation you said it was transitional, so could you just elaborate on that a little bit, since the staff's findings had that comment in it?
Sure, and I would agree with staff that this is technically spot zoning. There is no other HDR in the nearby area. However, spot zoning in and of itself is not prohibited. It is allowed when it's appropriate, and one of the ways it can be appropriate is if it's an appropriate transition between a lower density or lower intensity category and a much higher category. In this case, you've got medium density residential on one side and commercial on the other. The code itself in 3-2.8F actually specifies that HDR is an appropriate transition and uses those words between medium density residential and commercial. So although this would constitute spot zoning, that shouldn't preclude the board from approving the request.
Wayne Brisky, thank you very much. Board members, any questions of the applicant or the staff? All right, Chair will entertain a motion on the case.
Tim Pyle, I make a motion for Z 2206 that we do pass it, and with the notice and agreement with Ms. Bush that that it's more transitional than spot zoning.
Gary Salmon, second.
All right, Wayne Brisky, any further discussion? All those in favor say aye. Aye. Opposed? Motion carries unanimously. Thank you, Ms. Bush. Is there anyone else with any business for the rezoning hearing? All right, we will go ahead and adjourn the June 7th rezoning meeting. I think we may need maybe 2 or 3 minutes to kind of unwind everything. So let's go ahead and just take a 5-minute break, very limited 5-minute break before we go into the regular planning board meeting.
Michelle, this is the end of the meeting, so we are good to go. I'll go ahead and send you any kind of scripting to make it a little easier for you, and as well as everyone's names.
Perfect. Thank you so much.
Thank you, ma'am. Bye-bye.
Bye-bye.
want to be witness to nothing. We can't talk about that. We got our same way.
All right, folks, we're going to go ahead and go into the regular planning board meeting. A couple of the board members haven't stepped back in the room yet, but I'll go ahead and get rid of some of the technical introductions here. I'd like to call to order the regular planning board meeting for June 7th, 2022. We do have a quorum. We're only missing one of our voting board members. At this time, there are a couple out of the room, but they will be back in. Staff, do we have proof of publication?
Yes, sir.
Okay, and does that publication meet all of the legal requirements?
Yes, sir.
Okay, Chair will entertain a motion to waive the reading of the legal, and since we are not in quasi judicial anymore, you can stop saying your name before everything, so.
It is helpful, though.
Yeah, with motions especially. If you make a motion, it would be great to still say your name just because the staff's recording it, but, all right. Chair will entertain that motion.
Gary Sammons moves.
All right, thank you. Do we have a second?
Reed Rushing, second.
All right, thank you. All those in favor, say aye. Aye. Opposed? Motion carries. You've been previously provided the meeting minutes from the last meeting. Are there any additions, deletions, or corrections? Hearing none, Chair will entertain a motion to accept as is.
Gary Sammons moves.
We have a second.
Reed Rushing, second.
All right, all those in favor say aye. Aye. Opposed? Motion carries. You've received the planning board hearing package for June 7th. Chair will entertain a motion to accept that planning board package and the legal advertisement into evidence.
Jay Ingwell moves to accept.
Second.
Walker Wilson, second.
All right, all those in favor say aye. Aye. Opposed? Motion carries. We are going to go ahead and skip the updates and the follow-up report, go directly into our cases. Our first public hearing is case OSP 2022-02. The applicant is Joe Rector Jr., agent for Charles and Margaret Bird, who are the owners. Hillock Drive, 40.38 plus minus acres, from conservation neighborhood to MUS, which is mixed use suburban. that the board review and recommend to the Board of County Commissioners for an adoption an ordinance amending the Escambia County Midwest Sector Plan Final Land Use Plan, Figure 2.01A, removing the parcel with the township and range noted, parcel number noted, 40.38 plus minus acres on Hillock Drive from the Escambia County Midwest Sector Plan, further amending Part 2 of the Escambia County Code of Ordinances, the Escambia County Comprehensive Plan 2030 as amended Chapter 7, Future Land Use Element, Policy Flu 1.1.1, to provide for an amendment to the 2030 Future Land Use Map, assigning a future land use category of mixed-use suburban. And at this time, Allison, do you want to do the introduction and then we'll bring Mr. Rector up? Or do you want him to go first? Okay, Mr. Rector, we'll go ahead and have you come up first. Good morning, sir. If you'll please state your name and address for the record.
Good morning, Mr. Brisky. Thank you, Board. My name is Joe Rector. I'm with Mullins LLC and representing the owners of the property on this request for the opt-out from the sector plan. I will yield my time here at the beginning to the staff because what I would like to acknowledge is that we had a chance to review the staff's analysis. As they had noted here, this is, I guess, the 9th opt-out that has come before you. In the short time period that these have been coming before you, this process seems to have been fine-tuned and taking shape because it was kind of nebulous at first, and it seems like that the last few have kind of brought everything into focus. This parcel is adjacent to, it shares a common property corner with the piece that was brought before you in the previous meeting. The Westmarks brought before you with a parcel, it was called the Owen parcel. It's in this same sector plan area, and so I think a lot of the stuff that came from the report from the staff of those last few meetings and the things that have been fleshed out, they were addressed in the staff's report. We would like to attach that almost as an addendum to our submittal because they were spot on with every one of the aspects of their analysis. And the one that was the most important at the end in their conclusion was that this, in fact, was a decrease with the putting the conservation neighborhood on this parcel. As a thing that we had in our analysis that was a mistake was on the timing that the staff corrected, where they showed that this, in fact, had been a part of the adoption of the 2030 flu, where it was assigned an MUS at that time. And then when the DSAP overlay came in and applied conservation neighborhood, it then did rescind that back down, and that they did find that there was, in fact, a decrease down from the potential of what, with the LDR zoning, would have been 4 units per acre. This capped it at 3 units, and so therefore they did find that it was a decrease, and that was the crux of what our position was as well. So with that, I will let the staff do their presentation, and then I'll be available to answer any questions that may come up.
All right, thank you, Mr. Rector. Any questions initially? All right, thank you. Allison?
Okay, this is the opt-out OSP 2022-02 on Hillock Drive. Requesting the opt-out from Conservation Neighborhood and asking for the assignment of mixed-use suburban. This is a location map showing the property in question. This is the zoning map showing the underlying the LDR. This is the existing future land use and DSAP map showing the conservation neighborhood. And if you'll notice the top right corner of this outline property where she's got the cursor, that's the property he was talking about, those two Owens property that were just sent to the board. So this is the proposed future land use, the request for mixed use suburban. This is the Jacks branch there in JB 51. And this is the flood zone map. This is the prime soils map showing they do have some soils on site. This is our wetlands map. This is the aerial photo of the site. This is the public hearing notice sign that was posted on site. This is looking into the subject property on Hillock Road. Looking north along Hillock toward Ridge Lane. This is looking south on Hillock towards Neal Road. Looking across Hillock from a portion of the subject property. Looking northeast from the subject property. The applicant is requesting to remove a parcel from the adopted Escambia County Midwest Sector Plan, the Jacks Branch detailed specific area. The parcel is located on the west side of Highway 29 at the end of Neal Road and Hillock Drive. The applicant is also requesting that the Board of County Commissioners assign a future land use category of mixed-use suburban. The applicant stated that there is no immediate proposed development plans for the site. Based on the public records of Escambia County Property Appraiser, the parcels are currently used for timberland. The current underlying zoning for the parcel is LDR, low-density residential, allowing 4 dwelling units per acre. The existing land use derived from the adopted DSAP final land use plan identifies the parcel under the conservation neighborhood with a maximum residential development allowance of 3 dwelling units per acre. For the availability of facilities and services for the sanitary sewer, Emerald Coast Utilities did not supply wastewater to this region north of Wellline Road. Therefore, the development would have individual septic tanks, which require a minimum of a 1/4 acre lot, and a coordination with the health department is required. When a residential subdivision project is submitted, the maximum number of dwellings at 4 dwelling units per acre would calculate to 162 dwelling units. However, once the roadways, utilities are in place, septic tanks, and any other wetlands or endangered species are identified, the maximum number of dwelling units may not be able to be achieved due to those development constraints. Solid waste disposal. The demand requirements for solid waste is based on a population projection. The county has adopted a solid waste level of service standard of 6 pounds per capita per day. This amendment request for opting will not affect the population projections. Any development request will be reviewed and must receive approval through the site plan review or subdivision process. Potable water service. Potable water for this area is supplied by Cottage Hill Waterworks. The applicant provided a letter from the provider stating the availability for 98 single-family homes, and I also reached out to the water provider but received no reply. The level of service for potable water within Escambia County is 250 gallons per residential connection per day, and non-residential uses are based on equivalent residential connections to be calculated by the service provider. Potable water was analyzed for both the 5-year and the build-out development program. A conceptual potable water distribution system was developed based on the analysis and is available in Figure 4.03A of the DSAP document. Stormwater management. Based on the DSAP's original analysis for stormwater in the area of the sector plan, stormwater systems should be developed as regional systems and encompass multiple areas of development. Attempts should be made to design the stormwater treatment and attenuation systems and supporting conveyance pipes and swales as complete systems. For stormwater management, private developments are responsible for constructing on-site stormwater systems and infrastructures that connect the stormwater to regional county stormwater systems. This amendment itself will not rely on stormwater requirements or calculations. However, stormwater will be an important aspect of the review and permitting process. All developments are required to meet or exceed the standards established by the Northwest Florida Water Management District. Once a development is proposed, the project will be reviewed and must receive approval through the development review process. Excuse me. Traffic, streets, and access. This property is located on Hillock and Neal Road. The county does not implement traffic concurrency, but if the subject property were developed to the maximum residential density, the potential might be 162 units, not considering any right-of-way infrastructure, wetlands, or other issues that may result in a reduction of the developable land. A traffic impact screening is recommended by the Transportation and Traffic Department. and any future development proposed will require formal submittal, review, and approval through the county process of DRC. Rec and open space. The intent of open space is to serve as a buffer to protect and preserve areas of significant national resources and wildlife habitat, while offering passive recreation opportunities to residents. The mixed-use suburban land use category allows for residential, retail sales and service, and recreation as permitted uses. The county does not have a level of service standards for recreation. However, any development could create usable and accessible open space, which would contribute to the overall interconnectivity of a development. This amendment would not rely on open space requirement. However, any development would go through the development review process and have to meet all standards. Public school element. The Escambia County School District staff is part of the reviewing process, and based on the public records of the Escambia County, the assigned schools are Jim Allen, Ransom, and Tate. The school district staff is part of the process, having the ability to comment on all proposed projects and school capacity in Escambia County. For single-family residential, low-density zoning of 4 dwelling units per acre, which would allow for a maximum of 62 dwelling units. The student population is as follows. For elementary, it's 30.78, middle 15.39, and high school is 15.39, totaling 61.59 students. Mixed-use suburban, which allows 25 dwelling units an acre, that would allow a maximum of 1,015 dwelling units. The student population is as follows. The elementary would be 192.85, middle school would be 96.42, high school would be 92.42, totaling 385.70 students. Regardless of the mixed-use suburban numbers I just quoted, the zoning district of low-density residential dictates the density. If the need arises, there may need to be adjustments made to the school zoning boundaries to balance capacity among the schools, but Escambia County has not adopted school concurrency. Therefore, this amendment would not affect the student population. Impact on natural resources. For wellheads, based on our geographical information system, the subject parcel is not located in a wellhead protection area. The requirements for wellhead protection areas will be reviewed if the project is proposed, as well as possible permitting from outside agencies will be necessary. Historical significant sites. The applicant provided documentation stating that there are no previously recorded historical resources within the parcel. The comprehensive plan has a section for historical preservation, and at any time during the development, if any artifacts are discovered, they are to cease construction under the policy Objective Flu 1.2 Historical Resources. Natural environment. As stated in the sector plan document, section 5.01 Natural Resources, the DSAP contains significant wetland systems that are listed as a regional significant natural resource by the Emerald Coast Regional Planning Council, and the final design was to avoid and minimize wetland impacts to the greatest extent possible. There are hydric soils and prime soils on site, which may suggest the presence of wetlands and prime farmland. Wetlands and surface waters may be subject to jurisdictional regulations by the U.S. Army Corps of Engineers under Section 4.04 of the Clean Water Act. When a project is submitted, an environmental study will be necessary. Comprehensive plan requirements for changes in the DSAP. Components of the sector plan include aspects such as community design, environmental analysis, transportation, guidance, economic development principles. The final land use plan identifies the overall boundaries of the sector plan, the distribution, the extent, and location of land uses. The land use plan and development program provides specific growth data with development program calculations and assigning permissible densities and intensities by various uses. The type of development and corresponding densities were assigned based on the proportionate share of the overall sector plan. The parcels on the north of Wellline Road in the Jacks Branch DSAP with access via Hillock Road in the conservation neighborhood. If approved, the requested removal of the parcel from the sector plan would not create a fragmented DSAP. the parcel size in relation to the individual DSAP land use category and in relation to the overall sector plan and the aggregate acres of the granted opt-outs. The applicant's parcel, approximately 40.6 plus 60 plus minus acres, is located within the Jacks Branch DSAP and is specifically identified in the land use map under section JB Jacks Branch 51. Based on the staff's calculation, utilizing the data, the document, the total developable acres in the entire sector plan is 8,611.80 acres. The applicant's parcel represents 46% of that existing developable acreage. Under section 2.02 development program calculations, the total residential development acres in the Jacks Branch under the conservation neighborhood is 2,565.60 developable acres. Removal of the applicant's 40.38 plus or minus acres would result in a decrease of 1.57% of the available developable acres. The specific Jacks Branch DSAP land use parcel in section JB 51 are identified as conservation neighborhood, which has total developable acres of 238.90 acres and a maximum density of 716 dwelling units using the high density allocation. So this is the 9th opt-out that's been requested and submitted by county staff. If approved, the total sector plan aggregate acres would be 304.41 acres. Assuming a maximum theoretical build-out under the mixture of uses, the DSAP area would produce approximately 27,145 jobs. When analyzed using the maximum residential build-out of 23,000 dwelling units, the result is a jobs to employed residents ratio of 1.18. It should be noted that although there is no single perfect ratio, an area is generally considered to be balanced if it has a jobs to housing ratio of roughly 0.8 to 1.2. If the proposed amendment is approved, the resulting job to housing ratio would be 1.23. The existing transportation infrastructure and any effects the proposed may have on the capacity of that infrastructure. So the traffic and transportation staff did review the opt-out case, and they do have their comments below. And they're also here if you have questions from the transportation department. The property in question is located on the west side of Highway 29 and north of Neal Road. Both Hillock Road and Neal Road are 2-lane residential roads without paved shoulders. Also near this location, North Highway 29 is a 4-lane divided roadway with 11-foot travel lanes and 4-foot paved shoulders. The posted speed on Neal Road and North Highway 29 is 35 miles per hour and then 65 miles per hour respectively. North Highway 29 is functionally classified as an arterial roadway with an annual average daily volume of 21,500 for 2021. The Traffic and Transportation Department had performed a traffic impact analysis, and as a result, no traffic capacity concerns related to the future land use opt-out case. However, it should be noted that build-out conditions under current zoning will impact operations on both Hillock and Neal Road. It is recommended that a traffic impact analysis be performed as part of any future development. The underlying zoning district and the compatibility of the surrounding DSAP and land use designations. And I'm not going to read what all the permitted uses would be. The consistency of any requested future land use designation with the underlying zoning. The requested mixed-use suburban future land use category would be consistent with the underlying zoning uses, densities, and intensities allowed by the low-density residential LDR. And then there's listed all the description and the general uses and allowable uses for the mixed-use suburban, which are residential, retail sales, services, professional offices. Prior to the adoption of the DSAP, the 2020 future land use designation for this parcel was AA 15. And with the adoption of the 2030 future land use, the future land use was mixed use suburban. Analysis to consider whether the applicant lost development rights or was effectively downzoned as part of the sector plan adoption. Prior to the adoption of the Midwest Sector Plan, this parcel was zoned VR2, which allowed one dwelling per 3/4 of an acre. Based on that existing data, the residential density for the parcel was in fact decreased by the adoption of the sector plan and the assignment of the conservation neighborhood, only allowing maximum 3 dwelling units per acre. If approved, any future development associated with these parcels would be evaluated by the Development Review Committee, utilizing the current zoning regulations while addressing and minimizing any potential impacts that the proposed development could have on the characteristics of the existing low-density residential development. If approved, the sector plan boundary map would be adjusted accordingly to reflect the removal of the parcel. If approved, the parcel will be assigned the requested future land use mixed-use suburban. And that is staff's analysis.
Okay, thank you. That's a mouthful. That's a lot. Okay, any questions from the board members? All right. Mr. Rector, anything that you want to add at this point? We do have someone signed up to speak from the public. Okay. All right, so we'll go ahead and move forward. Ms. Rogers? Good morning. If you'll please state your name and address for the record.
Surely. Is that good? Can you hear me?
Yes.
Okay. My name is Jacqueline Rogers. I live very close to this property too, 1420 Ridgeway in Cantonment. I think it's interesting that we can't consider all these opt-outs as a whole. You said they have to be individual cases, but we want to attach, the findings from the last one. So I want to attach the attorney letter that I forwarded to you that gives the case law that does require full analysis for the future land use, not constrained by the Land Development Code, which would include the zoning district. It should be noted on page 10 of 12, the staff says, under the traffic analysis, it should be noted that build-out conditions under current zoning, which they're not even supposed to constrain to that, they should go to the full 25 dwelling units, but even under current zoning, will impact operations on both Hillock and Neal. It's recommended that a traffic impact analysis be performed as part of a future development application. The law is clear. Attorney Grosso sent you the letter to the board that I forwarded to you. It's demanded now at this stage. That's what the law says. She said several times we don't have any concurrency for traffic. We don't have any concurrency for school. That's why you have to do the analysis now. Once you allow it, they can't stop it because we don't have concurrency. It's not good to wait until development review. The state statutes require facilities infrastructure, capacity analysis to be done at the time of the comp plan request. That's what I was telling you about statute 163-3177. Staff use factors outside of the comprehensive plan, mainly the zoning, to constrain their analysis. That's not reacting appropriately to the available data and the existing case law. And I won't go over those, but Judge Folks, who recently ruled against me and has this status in April 2022 with Mr. Grosso, said is not professionally acceptable to do less than the maximum analysis. And he goes into that in the letter. So I hope you all read that. I forwarded it to you. The decision to opt out and change the FLU cannot be based on the landowner's desires, the policy of the board, we don't like the sector plan anymore, and fairness reasoning. Like the applicant said in his application that they did not lose any development rights because they had not applied for any development orders or anything like that. Now he's changing that, which is disappointing. But amendments are not in compliance where the local government first takes a position and then directs the planners to develop data and analysis to support it. That's what you're doing. On page 1, the applicant stated that there are no immediate proposed development plans for the site, but throughout the applicant's application, it says 98 single-family homes, and that's what he submitted to the Waterworks. You had the testimony last time, and I would like to attach that to this also, that Cottage Hill Waterworks does not have the capacity for these upzonings. The residential density Okay, I already said that. He said it had increased. Mr. Rector said in his application that the residential density had increased. So if you take it, those dwelling units at 1 per 3/4 of an acre or 3 per an acre. So I'm just going to finish. I could say so much more. The data and analysis is not there for the natural environment, the stormwater, the potable water, and the open space, all things that were important, and they quote the sector plan, but they're not there. The analysis just wasn't done, and it's supposed to be done at this stage. Homes to job ratio is out of whack, and this is a fragment, unless they're saying that this other one is a slam dunk, which it's not approved yet. Thank you.
Thank you, Ms. Rogers. Anything you'd like to add, Allison or Horace or any of the staff members?
No, sir. Other than I did notice that she said at the very last that it was a fragment, but it will not create a fragment. And a fragment is when you have parcels that are isolated from the other parts of the DSAP and cannot connect. And this was not create a fragment.
Okay. All right. Board members, questions of the applicant or anyone who has spoken?
I have a question for Allison. On page 23 of the entire packet, under number 9, I'm having a hard time following the up cylinder down, or the loss of their development rights. Prior to adoption of the Midwest Sector Plan, it was 1 dwelling unit per 0.75 acres. And after adoption, it was 3 per dwelling acre. Can you explain to me how that is a decrease?
So when it was the AA15, the 2020 flu, they had 1 dwelling unit per 3/4 of an acre. Then the mixed-use suburban, which allowed 25 dwelling units an acre. And now with the conservation neighborhood, they're only allowed 3 dwelling units per acre. So really the 2030 flu is really the only one that we're looking at, because that was the current one. It's kind of like when you had the old zoning, you can't go back and say, well, the old was. So the AA15 really isn't to be considered. The mixed-use suburban, which was the underlying prior to the conservation neighborhood. So it's really the 25 versus the 3 dwelling units.
So there's a step missing in here. The 25 per acre isn't listed.
Well, that's the mixed-use suburban. With the 2030 flu, the mixed-use suburban, the density is 25 dwelling units per acre. So, and I guess I didn't spell that out enough, but they were decreased when they hit the conservation neighborhood of 3 dwelling
Okay, you're clear now.
Okay. Any questions? All right, Mr. Rector, we'll give you opportunity to come back up and give some comments and give a closing on it.
Yes, Joe Rector again. Just a couple of items here. One, as you pointed out, that gets people confusing whenever they start talking about the zoning, and then the zonings that have changed because the zoning categories were redefined from whenever it was the A15 and the VR2 mentioned, and we switched over to the LDR, MDR, HDR, and those assignments got made separate from what we're talking about with this is the future land use. So that's where the confusion comes into this at times. So also about the Cottage Hill Waterworks, what we did at this time to address 2 of the questions talking about the 98, where was the 98? Of course, whenever you're doing this, you come up with something like, what would you do? What could be done? What's the criteria? The septic tanks, you got criteria that's got to meet 1/4 acre. So in a part of the process, you put lines on paper to try to figure out what could work, what could fit, and what a number would be. So that's where that 98 comes from, because you have to have something whenever you reach out to Cottage Hill and make the request. And it was part of our package as well that Cottage Hill's response was that they anticipated no problem with providing the water that would be required for something like that. So that's their opinion, and that's what we reached out for and got on that. And I think everything else, like I say, was pretty much covered in the staff's report, and we appreciate your time for that today.
Okay. Board members, discussion, questions, or a motion?
I just have a comment. I agree with Ms. Rogers on the lack of analysis up front. I mean, we're a planning board, and it should be part of this process. And the more data we have, the better decisions we can make earlier in the process. I think it's important. The sector plan it's suffering death by 1,000 opt-outs. That's a fact. But as we approve these, we're going to find out as development continues, we will not have the infrastructure to support the developments. We already see that, but until we take action on identifying the true max build-out potential and the impact it's going to have, we're going to see problems in the future. That's just my opinion.
Mr. Engel, just follow up to your comment there. Did you have specific things that you'd like to see the staff address in their findings that they're not addressing at this point?
I think they need to look at everything in total at the max potential build-out for the proposed changes with the schools, roads. I mean, the road analysis is incomplete. Like Ms. Rogers said, there's 2 roads there that are going to be overburdened if with a max build out. And I think we need to see that in this stage of the process. So all infrastructure, the same for emergency services. Those are probably the most important things: schools, emergency services, and then our basic infrastructure. Roads and that sort of thing.
Thank you, sir. Horace, I know you're
Yes, sir.
patiently waiting.
Yes, sir. Thank you, Mr. Engwell, for your comments. But I do want to say this again. From inception, from day one, the opt-out process, it has been challenged in circuit court. DO looked at it, circuit court looked at it. Judge made ruling on our processes, on what was submitted. Lawyers contested what the judge said. The judge looked at all of the data because they're the one that had the ultimate decision. The judge made the ruling. The judge made the ruling that what we have been presenting, it supports the state statutes. The judge, not the lawyer, not the dissenting opinions, the judge, they have the final decision. And they, one that supported the staff, supported their positions, and supported what was presented to them in all of these opt-out cases.
Thank you, sir.
I just have one follow-up. The judge may, the law may state that, and in my opinion, it appears that we're doing the bare minimum to meet the law, where maybe we could do a little bit more to keep our fellow citizens, to get buy-in from the fellow citizens, to show them, the true impact of a max build-out.
Thank you, sir.
Mr. Chair, I
Mr.
just, this goes back and forth, and I ponder if proper analysis was done prior to the DSAP. I mean, if you want to look at it that way, it's a chicken and the egg. I mean, quite frankly, it's the burden of a developer. If you purchase that property, when they do a traffic study, they're going to charge that developer to put the light up if it's required on that. That's how they pay for it. I'm not saying we should just go crazy and build out everything, but I think, again, it's chicken and the egg. If, the developers are paying for this, the school system, they have to plan on this by tax revenue. If there are more people coming in, there's an unbelievable demand for more housing, more rental properties, period. Do we just go crazy and throw out multifamily everywhere? No, that's the rub here. That's why we dissent, we argue, and I think it's all good. But I just say, when we say, there's not enough analysis, at what point? I mean, you're right. But the DSAP seemed to me the one with the least amount of analysis thrown on somebody, and I think it's just difficult for me to go back and say, well, you had this, but we took it away. Why? Well, because we put the DSAP over it, and now you can't have it anymore because we've got to wait and determine until the roads are they just going to build themselves and then we can build up to capacity? No, it's funded by the people that risk their money for developments and or, you know, whatever other development comes along. It's on their backs. They have to pay for it. I'm not against analysis, but I guarantee you that 162, that's never going to happen. I know just from the process that you should think like that. And I agree that when we look at a rezoning, perhaps, that you should look at all the potential things that could be there and use our minds. But I mean, again, it goes back to what's really, in theory, going to be in the market able to be built on this location. And they go through those processes during that, whereas I think people here think it's backwards. We should do that analysis prior to allowing them to have the rezoning, and I don't see how we could possibly ever do that. But again, my opinion, I just think that it's difficult for me to say no to an opt-out because the opt stands for an option, and I believe the option is the landowner, not our option. That's just my opinion.
Thank you, Tim. I tend to agree. I mean, I've said this several times that when an action that the county has put in place takes away someone's rights with their property, I think we have to rectify it, and I think that's what the county commission saw when they voted to allow these opt-outs, and we've obviously seen that there's demand for it because members of the public feel the same way. So I think, you know, you could add all kinds of additional analysis to it, and we could analyze it to death, and I think you still come down to the same conclusion, which is that when a property owner loses rights, we have to rectify it. It doesn't matter what the analysis says. When a property owner loses rights, we have to rectify it. So that's kind of been my position all along with this, and I was part of the original plan when it was put in place, and I can tell you that back then it sounded great. You know, it was intended to be a planning tool. We always get criticized that we're not really planning, that we're always reacting, and that was intended to be a planning tool, but I don't think that all of the analysis was done at that time, and all of the unintended consequences that could happen were pondered at that time. And so now we're left with this monster that we're trying to correct. So I always go back to my basic stand, which is how does this affect the landowner and, you know, what's been taken from them, and that's what I base my decision on going forward. So members of the board, any other comments, questions, discussions? Mr. Sam?
Mr. Chairman, I move approval of OSP 2022-02.
Thank you, sir. We have a motion. Do we have a second?
Second.
Second by Mr. Rushing. Any further discussion? All those in favor say aye. Aye. Opposed? All right, motion carries unanimously.
I would like to ask a question. So there was more analysis done on these last couple of cases related to schools. We contacted the schools and got those numbers for the LDR and also the mixed-use suburban. And also for potable water, I tried to reach out to them and got no reply. But I'd like to ask Mr. Engel, how would you suggest that we do more analysis on stormwater, since we don't know how big, what type, you know, how many units? How do we do an analysis on a what if?
No, I understand. I don't know if I mentioned stormwater, but if I did, I probably misspoke. But more so on roads, the traffic. That's, I think, where we need to dig a little bit deeper. And again, my issue is more with our process. Again, my vote reflects the same as my colleagues. There was a loss of development rights and that needed to be corrected. That's why I voted the way I did. But again, my issue is, if I did notice there was more analysis with schools and like you had mentioned with the water. So I appreciate that. So we're moving in the right direction. But again, I think where we're really lacking, and one of the most important things is traffic.
Ever since I came on this board, traffic has been an issue that I wish we could control more, and unfortunately, we don't have a whole lot of control over that. But I agree with you. I mean, all of us that drive around town understand traffic is a problem. So
And I think police and fire services as well. Where's the nearest? What capabilities or lack of capabilities do they have if there is a max build-out?
Yes, sir. Thank you. All right.
I'm inclined to, I tend to disagree with the chairman and others that everywhere I go around town is a traffic issue. And if you look anywhere in the country, there's traffic, there's places where you have to wait in line because of where you chose to live and conditions like that. And everybody has to wait somewhere sometimes during traffic. I get that. And I understand there's some tough areas out on 9 Mile Road, 29 coming into town, but those are based on choices people made to live further out. And I suspect, or I would like to think, they would expect that the buildup would occur around them and they would deal with those consequences down the road. But you can't eliminate traffic just by studying it. And you can't eliminate growth just by studying it.
All right. Any further discussion?
But you can identify potential issues.
Okay. All right. So that case has been voted on. We'll go directly into our next case, which is OSP 2022-03, Meredith Bush, agent for Sheila White, who is the owner. 1185 North Highway 29 and 1000 Block Highway 29, 4.69 plus minus acres, conservation neighborhood to mixed-use suburban. This is again a recommendation that the board review an ordinance amending the Midwest Sector Plan, final land use plan, removing a parcel as noted in the documents located along Highway 29 and a contiguous parcel also noted in our documentation located on Highway 29, cumulatively totaling 4.69 acres from the Escambia County Midwest Sector Plan, then further amending Part 2 of the Escambia County Code of Ordinances, the Comprehensive Plan 2030 as amended Chapter 7, Future Land Use Element Policy FLU 1.1.1 to provide amendment to the 2030 Future Land Use Map, assigning a future land use category of mixed-use suburban. And Ms. Bush, would you like to come forward, please?
Sure, thank you. Meredith Bush, 125 East Intendencia, here on behalf of the applicant. We are seeking to opt out this portion of the sector plan. Included in our submittal is data and analysis to include traffic counts on Highway 29. This parcel fronts 29. It was previously GBD. We've also included in the submittal DRC comments where the person who's under contract to buy the property went in to DRC, wants to construct a world gym, which is allowed in the underlying HCLI zoning category, but not because of the sector plan. That gymnasium is prohibited. Development rights were lost at the time of the imposition of the sector plan, and we would just ask, I don't want to rehash the last 9 cases, but we're similarly situated and would request to be allowed to opt out. The only thing I would address with staff's findings is the incompatibility of HCLI zoning and the DSAP. I would agree that the DSAP is incompatible with HCLI zoning in that it removes all those zoning rights So to that extent, I do agree with that statement. Otherwise, we are fine with staff's findings.
Okay. Any questions for Ms. Bush at this point? We'll give you an opportunity once we go through. Allison, I'm going to try to save you some time here. We don't have to go through and read, because I'm very quite confident that I read through the comments on this case and the previous one, and your comments are very similar. Since the findings of facts have been accepted as part of the hearing, I don't think we have to go through and read each of them, maybe just hit the high points, of each category so we can get it on the record. We do have a speaker on this case as well.
Okay. This is the opt-out OSP 2022-03, requesting to opt out from the sector plan, from the conservation neighborhood, and to have a reassignment of the mixed-use suburban. Now, I didn't write this case, so I'm going to have to look at it a little bit before I speak.
Okay, that's fine. I just was trying to save you a little bit of
That's
breath
fine.
on going through every single line.
Okay. So the request is to opt out of the Jacks Branch DSAP, and it's located just west of 29 between Neal Road and Well Line Road, and both parcels are vacant with a total of 4.69 plus or minus acres. And they are asking to be reassigned to the mixed-use suburban future land use category. And a pre-application was reviewed, as Ms. Bush stated, and the county staff for a health and fitness business, but they have not officially submitted an application at this time. So the underlying zoning for both the parcels is HCLI, and the HCLI and the mixed-use future land use, mixed-use suburban do allow 25 dwelling units per acre. And with the DSAP, the conservation neighborhood only allows a maximum of 3 dwelling units per acre. So for sanitary sewer, once a project is submitted, the application will go through the site plan review, ECUA in conjunction with ECUA to review for sanitary sewer, or the health department for septic tanks. So for potable water, a conceptual potable water distribution system was developed based on those analyses, and the potable water is provided by Cottage Hill Water Works. And then they have the Escambia County, the potable water is 250 gallons residential connections per day. Currently a commercial development has been proposed for the project site. Water lines extension that are necessary for new development is responsibility of the developer unless it's funded by the service provider, and they'll have to come through the site plan review process. So for the stormwater, they were given some preliminary comments for the stormwater by the county staff, and they did acknowledge that the system would be designed for a 100-year storm event. And however, even though they say commercial, assuming that there would be residential development proposed, it would result in more dwelling units. It could affect the numbers for the stormwater management and have to meet all the current standards. Okay, so for traffic, the county's Traffic and Transportation Department did provide comments and have no traffic capacity concerns related to the request to opt out. And then any development, commercial or residential, will still require submittal review and approval. And also connections would be needed to review anything from the, an approval from the FDOT. So for recreation and open space, this particular amendment to opt out wouldn't rely on open space requirements. However, any development wouldn't need to go through, of course, the review process. For the schools, if residential development was proposed, then you would have, for single family, the HCLI allows 25 dwelling units per acre, which would be allowing a maximum of 117.25 dwelling units. And the student populations for that would be, for elementary, would be 22.28 for middle, 11.14 for high, and 11.14 totaling 44.56 students. So they also did for multifamily residential, the HCLI elementary would be 12.31, middle would be 6.16, and the high 6.16, totaling 24.63 students. Mixed use suburban allows for the 25 dwelling units, which would allow for a maximum of 117.25 dwelling units. The impact to the natural resources. It's not located in a wellhead area, and the applicant did provide documentation for historical sites that they had received, that there were no previously recorded resources listed on the parcel. So for natural environment, the GIS showed no wetlands or hydric soils were found on the subject property, and then further evaluation will be required at site plan phase. Any tree protection and mitigation will be required during the site plan process. And additionally, prime soils were indicated on the subject property, yet the underlying zoning of HCLI does not have provisions related to protection of prime soils or farmland, such as agriculture or rural zoning categories. So the comprehensive plan requirements for the change to the existing DSAP, basically the subject parcel being on the eastern, in the eastern area of the Jacks Branch would access from Highway 29. They are in conservation neighborhood, and if approved, the request to remove from would not create a fragment under the JB 52. Parcel size in relation to the individual DSAP land category and overall sector plan. So removal of the applicant's 4.69 plus or minus acres would result in a decrease of the 0.18% of the available developable acres. So this would be the 10th request that was submitted and proposed by the county, and if it was approved, then the total sector plan aggregate acreage would be 309.10. For the jobs to housing, this would be a job to housing ratio would be 1.23. And the existing transportation infrastructure and the effects of proposal and capacity. That's the TTO staff. They added their comments that Highway 29 is functionally classified as an arterial road with an annual average daily trip of 21,500. The properties are adjacent to US 29, therefore the FDOT access permit may be required, and if so, there's a recommendation that a traffic impact analysis will be performed. Okay, so number 6, the underlying zoning district and the compatibility with surrounding DSAP. The existing parcels, currently HCLI. Surrounding parcels are zoned LDR and HCLI, and if removed from the sector plan, then you would see the other permitted uses that are shown here on the HCLI in LDC 3-2.11. Based on residential guideline language, the conservation neighborhood use is designed to allow clustered subdivisions or detached housing with a maximum density of 3 dwelling units per net acre. The underlying HCLI will show that the uses are more intense than these allowed by the DSAP conservation neighborhood. higher residential densities and commercial uses would be allowed and are found to be incompatible with the surrounding DSAP. Note that the more intense commercial uses found in the HCLI zoning districts are limited on properties that also have a future land use of mixed-use suburban, and within mixed-use suburban, outside storage is permitted only when adequately screened per the LDC regulations, and industrial-related uses would not be allowed. Additionally, the locational criteria for the HCLI zoning district would be achieved on the properties if the changes was approved, and the property is located along and directly fronting 29, previously Gateway Business District, GBD, and within the mixed-use suburban future land use category. The consistency of any requested future land use designation with the underlying zoning. The requested mixed-use suburban that they're asking for is consistent with the underlying zoning of the HCLI. The previous future land use designation with the 2020 future land use was activity area AA15, and the 2030 flu was mixed-use suburban. So the Gateway Business District, the GBD, was intended to enhance specific segments of 29 as a visually attractive, well-planned business community. With the adoption of the DSAP, the commercial development rights for the parcel were in fact decreased by the adoption of the sector plan and assigning of the conservation neighborhood under the DSAP, which was a designated residential development, maximum allowance of 3 dwelling units per acre. According to historic documents, there appears to be no residential development allowed in the previous zoning of the GBD. If approved, the future land use development associated with this parcel will be evaluated by the development review using the current zoning regulations, and also addressing and minimizing the impacts for the proposed development that they would have on the characteristics of the existing low to medium density development listed under the sector plan's land use. And that's the findings.
Okay. All right, board members, any questions of staff based on the analysis done? Go ahead, sir.
Allison, I just have one comment, and it's a great job. But to get back to my comment about traffic, you give the acreage stats for the cumulative opt-outs. You provide that. Maybe for traffic, we could, look at, max build-up, but I think we should look at, there are changing conditions here. So I think if we looked at the cumulative effect of the past opt-outs and the impact that it could potentially have on the traffic, that would be maybe a step in the right direction as well. But in other words, look at the effects of the changing conditions as a whole in a cumulative manner. That's more of a comment.
Thank you, sir. Any other questions? Okay. Ms. Bush, if anything you'd like to add? Okay. All right. Ms. Rogers? Good morning again, and if you'll just please state your name and address for this case, please.
Again, I'm Jacqueline Rogers, 1420 Ridgeway in Cantonment. All the analysis, again, is deferred here. The potable water, there's no analysis here that shows that there is capacity here. All the analysis, again, is deferred to development review. As to the effect on the surrounding properties, if you look at that, there's not even a little thing that says analysis. They just eliminated it. They just told you what the land uses are, didn't even do an analysis. Stormwater facility capacity is mandated by state statute at the comprehensive plan change. So whether they want to do it or not, at the max development, the assignment of mixed use suburban, which is 25 dwelling units per acre, that's how you calculate it. Because they can say they're going to do a world gym, but they could sell it to someone else that will do something. Once you grant that capacity, so that's why you do the max analysis. Traffic says there's no concern, but they recommend that a traffic impact analysis be done. It's supposed to be done at this stage. That's what it says in the statute. Open space, it's necessary to say what the effect will be on on the open space, because that was one of the sector plan's major goals in conservation neighborhood. That affects stormwater, that affects wildlife, that affects protection of natural resources. And every time you guys gloss over it. Schools, you have the cumulative effect of all these opt-outs. You're going to say, well, this development, at least you're getting to the 25 dwelling units on the schools. I applaud the staff for at least getting that far. But you don't say, what is Tate? Tate's at capacity. Ransom's almost there. The cumulative effects of the one that you just did north of me, now the one on Hillock, and now this one, you have to do those cumulative effects, and where are we going to be at? Prime soils were indicated, the staff said, in your staff analysis. The comprehensive plan says you will protect prime soils. There is no analysis done on what the effect will be on this loss of prime soils. You're going to use HCLI zoning, which is a land development regulation. That's not in the comp plan. You're going to use that as an excuse that there's no provision in that zoning category. That doesn't matter. This is a comp plan amendment. You are supposed to, your comprehensive plan says you have to protect prime soils. And I'll just point out the last thing staff found on page 13, that HCLI and the surrounding DSAP conservation neighborhood was incompatible, that those two uses were incompatible. So with the data that you have to react appropriately, you should deny this until more data and analysis is done. Thank you.
Thank you, Ms. Rogers. Ms. Bush, your closing statements, please.
Very briefly, while I appreciate Ms. Rogers' concerns, I agree with what Mr. Jones has stated previously regarding the court's determination that staff's manner of looking at this. I mean, this was the first opt-out that you guys did was the first time it had been done in the state. So while it may not be perfect, it is adequate. And we agree with staff's findings. My client did lose development rights in being placed within the sector plan. We're simply asking to have that rectified, as you mentioned earlier, Mr. Brisky.
Okay. Thank you.
Just for the record, our current land development, our current comprehensive plan, it does say that the comprehensive plan, the land development code implements the regulations of the land development code, of the comprehensive plan. It says that the land development code is the tool that we use to provide guidance to the general goals and specifics of the comprehensive plan. For example, in this case, if you just go with the comprehensive plan, say with the mixed-use suburban has many uses. But if you look at the specific requirements, because the zoning is heavy commercial, light industrial, it minimizes some of the uses because of the mixed-use suburban category that potentially can be assigned to this. So the land development code is implementing, it tightens up, it pulls back in those general broad guidelines. Look at it. So this answers your question on every one of them. The comprehensive plan says that the land development code in the first section implements, is the tool that puts teeth. Either it restrains, it cannot go, it gotta be consistent. It can restrain the goals of the comprehensive plan. And in this case, look at it, just answer your question that I asked. The ACLI, the mixed-use suburban, some of those uses that bring up, again, I'm closing, it is restrained because of the heavy commercial light industrial zoning. So it does protect the mixed-use suburban category in that area because of the zoning, it does.
Thank you, sir. Any further questions or comments? Chair will entertain a motion.
I move to approve OSP 2022-03.
Thank you, Mr. Sammons. Do we have a second?
Second.
Second. That was Mr. Rushing. Any further discussion? All those in favor say aye. Aye. Opposed? All right, motion carries unanimously. Good luck with it. Thank you. All right, we'll go directly into action discussion items. Do we have anything for the board today? Anything to discuss? Okay. Public forum, anyone who wishes to speak, public forum. All right, hearing. Okay. Go ahead, Ms. Rogers.
Jacqueline Rogers. Did any of you read this, or did any of you take the time to read the letter I forwarded from Attorney Richard Grosso?
I did.
Okay. I'm so frustrated because, and this is in general, I'm just not trying to win cases. I have to just speak the truth. You guys have to make the decision you're gonna make. And then, but I think we can do better in Escambia County. It says right here, a land use change must be supported by an analysis of the full impacts, the maximum densities, intensity uses that the new land use category would allow. It is improper to limit that analysis based on development limits in the Land Development Code or a specific development order, because both may be subsequently amended to allow greater uses and intensities or densities up to that maximum allowed in the plan. When you let it go to mixed-use suburban, it goes, or whatever land use you're going to do, but let's just take mixed-use suburban in general, 25 dwelling units per acre. Okay, they're going to say, well, we only have LDR, we only have 4, but that will never go back to the state if they come back to rezone. That'll be a local decision. And local decisions are often political and not always supported. And so that's why the state statute requires you in your long-range plan, in your comprehensive plan, in your future land use maps to be more supported by data and analysis. And that's why when you change a land use, it should be supported by data and analysis, not a policy that we need to restore property rights. Never was it proven that somebody lost property rights. There are statements made by that, but there were no development orders applied. That's what property rights are established on, and that's established by the courts. You don't have to agree with that statement, but there, again, in just right here in April, the Attorney Grosso, who wrote this letter for me, quoted that it is professional planning practice to analyze maximum development potential to determine the maximum density and the maximum intensity associated with a future land use map change. It's not professionally acceptable to do less. That's what Judge Folks, the one that ruled against me in this last court, that's what she just said in April 2022. So this has been established. This is now case law. I don't want to see us go to DOA hearings. You don't know how difficult they are. I didn't have an attorney that time. The Westmarks had an attorney, and they had a future land use planner, and Judge Folks believed them because they had professionals. I didn't. This time, I'm bringing you professionals, and thank you, Mr. Brisky, for reading that. I do appreciate that. It says data and analysis demonstrating the compliance of the land use amendments with both state law and your county's own comprehensive plan must be gathered and analyzed at the plan amendment stage. This cannot be put off to subsequent zoning or development approval decision. Staff keeps saying this is too hard to say 25 dwelling units per acre. What could this allow? What would the effect of 25 dwelling units as far as stormwater be on the surrounding properties? Our properties in our neighborhood are flooding already. So what will be the effect of all that impervious surface? Municipalities all over the state are already doing this. This is not too difficult. We need to up our game. If you guys are going to be the planning board, you should know the state statutes. You should follow the rules. It's not what we like to do here in Escambia County. It's what the statutes require. And if I can gather momentum, I know my time is up. If I could gather momentum, I will challenge this more until we get to where I can stay home and I can trust that you guys are doing your job and that the staff is doing your job. One thing that I just have to correct real quick. Mr. Jones said this went to circuit court, never went to circuit court. Didn't have the money for a lawyer. It went to Division of Administrative Hearings, and that's all it went. I did not have a lawyer. I'm pro se. I suck at being a lawyer. But I'm gathering forces if I can because I want a good Escambia County. I'm not against development. The Mr. Rector even said they had more density than before. So yes, some future land use that really doesn't exist with the sector plan underneath and has to be reassigned is still there magically somehow when the staff wants to say that they were downgraded. It's just frustrating, and thank you for letting me express that frustration.
Thank you, Ms. Rogers. Okay, Horace, anything, director's review, anything that you'd like to tell us about? All right, Mr. West, anything from county attorney's report?
Nothing to report, Mr. Chairman.
All right, thank you, sir. All right, our next meeting will be July 5th.
Can I enunciate that a little more? July 5th is the day after 4th of July. So please keep in mind if you're not at work on Monday to come here on Tuesday because I need a quorum. July is a very busy month as far as BCC meetings and things like that, so I may not be able to reschedule.
And I may possibly be out of town that week. So Mr. Pyle's already left, so he'll be excited to hear that.
I will
But,
send an email out if you guys can look at your schedules and kind of give me a heads up if you'll
Okay.
be here or not. Let me know if I have a quorum.
Okay. All right, very good. Anything else, any announcements, communication for the board? All right, then we are adjourned. Thank you.